Showing 1 o'clock. Are you guys ready?
Ready to roll.
All right, well, good afternoon, everyone. This meeting is called to order. Mr. Trillman, has anyone signed up for public comment?
Good afternoon, Commissioners. I believe we have one individual who would like to address the Commission. Cynthia Pearson, go ahead and unmute yourself and indicate your name and affiliation for the record. Ms. Pearson, you may be on mute.
Mr. Trillman, she's not in the room yet.
Commissioners, that is all the individuals that we had pre-registered for public comment this afternoon.
Thank you, Mr. Trillman. Good afternoon, Ms. Miller.
Good afternoon, sir.
I understand we have some cases to reconsider on agenda item 3. Is that correct?
Yes, sir, that is correct. Commission Appeals is going to request letters of continuing jurisdiction in 3 cases today. Case numbers 2501668 and 2542322 were both voted on docket 31 on August 4th, 2020. In case number 2501668, the commissioners voted to grant the motion for rehearing, deem the commission appeal timely, and resubmit on the merits. And in the other case, 2542322, the commissioners voted to resubmit the case to a future docket. In both cases, decisions on the merits were accidentally and erroneously mailed before the cases were resubmitted for the commissioner's review. The third case is similar. This one was originally scheduled to be voted on docket 31, case number 2509834. It was not voted because it was removed from the docket prior to the vote. A decision on the merits was erroneously mailed before the case could be resubmitted on a new docket. In all 3 cases, the appeal deadlines have passed and there's no indication of any appeals being filed, but the decisions are void. So Commission Appeals is requesting to issue letters of continuing jurisdiction so that those cases can be resubmitted to the commissioners. Commissioner Alvarez?
I agree.
Commissioner Demerson?
Agree as well.
And Mr. Chairman?
I agree.
Thank you very much.
Thank you. Let's move to tax liability cases on agenda item 4. I believe there's no tax cases on docket 35 and 3 tax cases on docket 36.
That is correct, sir. So moving to the cases on docket 36. The first one is case number TD-19-059-0419. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
My vote is to sever the general partnership's unpaid taxes from the limited liability company's unpaid taxes. With respect to the general partnership's unpaid taxes, I vote to agree with the staff recommendation. With respect to the LLC's unpaid taxes, I vote to grant the individual a hearing under TWC's Rule 815.113.
Jerry, let me confirm real quick and then get right with you.
Yes, sir.
Mr. Chairman, I'd like for us to have this case resubmitted and maybe with some additional commentary on a future docket regarding the comments that you just raised. I think we can get there with trying to get a little additional commentary that would help us look into something that we're interested in here.
I would agree to that.
All right, we will resubmit this case on a future docket.
Okay, thank you.
Thank you, sir. The second case is TD-20-072-0320. Commissioner Demerson?
This one, I agree in part and disagree in part with staff recommendation. I agree that the named PEO client companies are responsible for wage reporting and taxes for the period PEO was not properly licensed by the Texas Department of License and Regulations. However, I do not agree that the client companies should be financially penalized for their PEO's licensing oversight, because nothing they did caused the PEO license with the TDLR to lapse. They have good cause for an abatement of the interest and penalties they unknowingly incurred during that period. Under Commission Rules 815.107B3 and 815.109F, good cause exists for an extension of the due dates for the wage reports and unemployment tax payments by 60 days from the mailing date of this decision.
Thank you. Commissioner Alvarez
I agree with staff's recommendation.
and Mr. Chairman?
I concur with Commissioner Demerson.
Thank you. And the final case is TD-20-087-0820. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
Thank you very much.
Right. Apologize for this. Our public commenter, after I think some technical difficulties, has been able to join us on the line. So Ms. Miller, let's hit pause right ahead of fair housing cases and go back to agenda item 2, public comment. Mr. Trobman.
Yes, Ms. Pearson, if you want to go ahead and unmute yourself and introduce yourself and who you represent, and proceed.
Good afternoon. I'm so sorry to be causing you any technical difficulties today. I appreciate this opportunity, Commissioners and Chairman. My name is Cynthia Pearson, and I oversee the Day Nursery of Abilene nonprofit child care program in Abilene in the West Central Texas Workforce Solutions Board area. Our program is the city's largest, most comprehensive child care program and has been providing child care for children birth through the age of 10 for working parents since the early 1970s. You've probably heard me say that before. Since inception, we have served primarily low-income working families and were initially a Title 20 center and also a longtime partner with the United Way of Abilene, receiving community investment funding, which is used to help families who have child care needs but don't qualify for or cannot access CCS funding. All of those families contribute to the cost of their child care through payment of a copay. My public comments today are primarily to thank you 3 commissioners and the TWC leadership and child care staff for the amount of attention given to assure that the subsidized child care industry in Texas can adequately respond to and address the needs of essential and low-income working parents with young children during this pandemic. In the spring, when parent copays were absorbed, that helped so many of our families, and when the 25% enhancement funding was first implemented for open child care providers, we truly felt like we were able to breathe just a bit. Thank you. And when it continued month after month, we were overjoyed and very grateful. You have no idea what a difference this has made. We have been able to invest these funds into our program and services, which have undergone a number of extra steps, enhancements, etc., by our staff, families, and children, and program in general in a number of ways due to the pandemic. We have done all we can to retain a sense of normalcy while going above and beyond. In addition, we tried to be sure that young children and their families were celebrated during the work week of the young child in April, and really to do some extra appreciation during Child Care Appreciation in May. We've provided our staff with extra PPE needed when we were unable to access some of the free resources that we understood were going to be made available to us. We utilized and paid for enhanced services from our janitorial staff to hire them to do extra heavy-duty, in-depth sanitation. We provided additional resources needed for elementary-age children, which our staff virtually homeschooled for the remaining 3.5 months of the school year, as their parents worked in deemed essential jobs by the governor. In addition, the funds contributed to extra activities we provided and paid for the limited outings for our summer camp program to provide a fun time for elementary-age children who continue to be in our care during this summer. Close to 100 children participated in our summer camp. Because subsidized child care rates received in our area have been historically some of the lowest in the state, these additional 25% dollars in funding made a tremendous impact. Thank you so much. Thank you again for all you have done, for the extra funds, and for also approving the enhanced rates of 25% through the end of the year as decided and communicated out on August the 20th. There's a story referenced in the Bible where only one turned back and said thank you for a miraculous healing. I hope that doesn't happen in this case and that you hear from many of us. On behalf of the hundreds of providers in our state, and the thousands of children served as a result, we thank you.
All right, well, thank you. That I think concludes public comments. Thank you so much. Let's move back to agenda item 5. This is fair housing cases. We have no fair housing cases on our agenda today. Is that correct, Ms. Miller?
That is correct. No fair housing cases.
Let's move then to agenda item 6. We have no wage claim cases pulled for additional discussion on dockets 35 and docket 36. Is that correct?
That is correct. No wage claim cases pulled for additional discussion. You should already have received the short form dissent lists for 35 and 36.
I move we accept staff recommendations on the remaining wage claim cases on dockets 35 and 36.
I second the motion except for those cases on which I am dissenting, as reflected on the wage claim short form dissent list for docket 35 and 36.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the claim short form dissent list for docket 35 and 36.
Motion passes with the exceptions noted. We'll move to agenda item 7 and consider cases on docket 35. Proceed when you're ready.
Thank you.
Case number 2478062. Commissioner Dimerson.
The AT decision should be modified. I do not dispute the good cause finding. As to the job separation, the AT decision is fully supportable. The final incident occurred when the claimant, a shuttle bus driver, struck a guardrail while driving, causing damage to the bus and the guardrail. The claimant admitted to the final incident, but denied being negligent, stating that the accident occurred because she yawned, which was beyond her power to control. This denial is tenuous at best. The claimant also provided multiple inconsistent statements regarding the final incident, rendering her testimony unreliable. The preponderance of the evidence soundly supports a finding of misconduct, and as such, rehearing this case for additional evidence is unnecessary. The claimant's negligence constituted mismanagement of her position of employment, and we should modify the AT decision. The claimant had good cause for her non-appearance, misconduct, no chargeback, sever adequate response.
The case should be reheard. The claimant established good cause for her non-appearance because she didn't receive the hearing notice until after the hearing. Regarding the job separation, the employer provided a video for the hearing. However, the hearing officer was unable to access the video during the hearing. As such, the case should be reheard to enter the video into evidence and allow the claimant an opportunity to provide testimony regarding the video. The claimant had good cause a rehear to enter the video into evidence and take any necessary testimony.
Modify the AT. Claimant established good cause for AT1, misconduct, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez, I have your dissent.
Case
Next
number,
case.
case number 2484452. Commissioner Dimerson,
We should modify the appeal tribunal decision. I agree with the suitable work decision, but disagree with the job separation. The job separation occurred when the claimant, who had been living and working in Dallas, moved to another city about 40 to 50 minutes away. Even though the employer continued to offer the claimant work, she refused the assignments due to the distance. I agree that the commuting distance was substantial, but disagree that it gave the claimant a good cause to quit. It was the claimant who changed the hiring agreement by moving too far away to accept assignments. Because the claimant moved for personal reasons and no longer accepted assignments while work was still available, she quit without good cause connected with the work. We should modify the AT decision, voluntary leaving, no chargeback, adequate employer response. The claimant did not reject an offer of suitable work.
The decision should be affirmed. The claimant's client could no longer obtain coverage for her attendant services because of his health care changed. The claimant contacted the employer for additional work, but all the employer had to offer the claimant was a one-day assignment, which was not comparable to the 28 to 32 hours per week the claimant had been working. The claimant turned down the assignment. The claimant was only willing to take on assignments that were 20 hours per week. The claimant had good cause to turn down an assignment that was not comparable to her prior assignment. With regard to the suitable work issue, the job offer on appeal was made prior to the claimant's initial claim and therefore cannot be considered an offer of suitable work in the claim year. Affirm the AT, no voluntary leaving, chargeback, no offer of suitable work qualified.
Modify the AT, voluntary leaving, no chargeback, adequate employer response, no suitable work, disqualification.
Short form dissent.
Thank you, Commissioner Alvarez.
case number 2481747. Commissioner Alvarez,
The AT decision should be affirmed. I agree that the AT decision that the employer did not establish good cause for the non-appearance at the AT1 hearing. On the separation, the claimant and a coworker were let go during a contractual dispute with the employer over hundreds of thousands of dollars. When the claimant returned from vacation, the employer had locked the claimant out of the building, his email account and phone system, and the computer system. The owner of the company was not at the office. The claimant left the building and contacted the employer through his attorney. The claimant and employer met 2 days later, at which time the employer discharged the claimant. Given the claimant's access to the building had been revoked, and claimant did not even have authorization to be on the premises, given that he could not access the phones or computers, his decision to leave the premises and contact the employer through his attorney was reasonable. The claimant kept in reasonable contact with the employer and did not abandon the job. The claimant was simply fired under a pretext due to the contractual dispute, which did not constitute misconduct connected with the work. Affirm the AT, no employer good cause for non-appearance at AT1, no misconduct, chargeback.
We should reverse the appeal tribunal decision on good cause. The employer's attorney did not register for the continued hearing due to the disruptions in the attorney's office operations caused by the COVID-19 pandemic. Thus, because the employer was prevented from participating due to circumstances beyond its control, the employer established good cause for its non-appearance, and the case should be resubmitted for merits testimony. But even if the employer did not have good cause for missing the hearing, the available evidence established that the claimant initiated the job separation. The parties agreed that during text messages between the claimant and the owner, the claimant was unequivocally told he was not fired. Thereafter, when the claimant returned to work and had issues with his office accessibility, instead of reaching out to the employer for clarification, the claimant assumed he was fired, surrendered his key and credentials, and walked out, leaving the employer with a reasonable impression that he had quit. By failing to clarify his status, the claimant quit without good cause connected with the work. We should modify the AT decision. The employer did not have good cause for its non-appearance, voluntary leaving, no chargeback, adequate employer response.
Can you confirm the case number for me, please?
Yes, sir. I believe it was misstated earlier. It's case number 2487147.
Okay, thank you. That's what I had. My vote is affirm the AT. Employer did not establish good cause for AT1. No misconduct charged back.
Short form dissent.
Thank you, Commissioner Demerson. I have your dissent.
Thank you.
Case number 2500014. Commissioner Alvarez,
The AT decision should be modified. I agree with the AT2 that the claimant established good cause for their non-appearance at the AT1 hearing. On the timeliness issue, the claimant provided credible testimony and a written statement in his appeal to the AT that he did not receive the initial determination in his mail, which was why his appeal was late. His appeal should be deemed timely and the case resubmitted on merits. Modify the AT, claimant had good cause for their non-appearance at AT1, timely AT appeal, and resubmit.
We should affirm the appeal tribunal decision. First, I do not dispute the good cause finding. As to the timeliness issue, the claimant's testimony, which attempted to explain his late appeal, was neither credible nor persuasive. In addition, the period for filing a timely appeal preceded the agency's technical difficulties by several weeks, so that might have played a factor. The claimant failed to effectively rebut the presumption of receipt. His appeal is not timely, and we do not have jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision. The claimant had good cause for his non-appearance. The claimant filed a late appeal, misconduct, no chargeback.
Modify the AT. Claimant established good cause for AT1. Timely claimant appeal resubmit.
Thank you. We will resubmit the case.
case number 2524253. Commissioner Alvarez,
On the good cause issue, the AT2 decision in this case is not supportable. The claimant was unable to appear for the AT1 hearing due to the death and funeral of her young grandson. She therefore had good cause for the non-appearance, and her petition to reopen should be granted. This case should be reheard on the merits of the job separation. The AT2 took no substantive testimony from the claimant about her job separation. Additionally, there was no documentary evidence available before the AT2 that was not addressed or made a part of the record. The case should be reheard to adequately develop the record in this case. Reverse AT2, claimant had good cause for their non-appearance at AT1, and rehear the case on merits.
The AT decision should be modified. I do not dispute the claimant had good cause for a non-appearance. As to the job separation, the claimant's denial of wrongdoing is not credible considering the multiple emails and witness statements and evidence regarding the claimant's conduct and attitude. As such, the evidence established that the claimant was disrespectful and insubordinate to her supervisor, and we should modify the AT decision. The claimant had good cause for a non-appearance, misconduct, void chargeback.
I concur with Commissioner Alvarez.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
case number 2526545. Commissioner Demerson,
The appeal tribunal decision should be affirmed. The claimant's clock was behind and she called in late to the hearing. As such, she was not prevented from attending the hearing due to circumstances beyond her control and did not have good cause for a non-appearance. Regarding the job separation, while I empathize with the claimant's reasons for quitting her job, she did so for personal reasons and without work-connected good cause. We should therefore affirm the AT decision. The claimant did not have good cause for a non-appearance, voluntary leaving.
With regard to the good cause issue, I agree that the claimant failed to establish good cause for her non-appearance. Nevertheless, the underlying decision is not supportable. The claimant quit her job to move to Illinois and take custody of her five nieces and nephews after one of the children was sexually assaulted. The claimant's reason for leaving was urgent, compelling, and necessary, so as to make the job separation involuntarily. Modify the AT, no good cause for the claimant's non-appearance, not disqualified, urgent, compelling, and necessary.
Modify the AT, claimant did not establish good cause for AT1, no voluntary leaving, urgent and compelling.
A short form dissent, Chair.
Thank you, Commissioner Dimerson. I have your dissent.
Thank you.
Case number 2531706. Commissioner Dimerson,
The commission should grant a rehearing in this case. The employer presented several pieces of evidence in its appeal to the commission, including video of the final incident, customer emails describing activity attributed to the claimant. The commission should grant a rehearing to admit this evidence into record and to confront the claimant with the video of the final incident. Accordingly, we should hold a rehearing for the purposes so stated.
The decision should be affirmed. The employer alleged that the claimant broke a bunny statue and misapplied a cleaning product, which damaged a table. The claimant denied that she broke the bunny or misused the cleaning product. The employer alleged that it had a video of the bunny incident, but did not provide it to the AT. The employer provided no evidence to show that the claimant misused the cleaning product, such as training materials or a label from the product with directions for application. The employer did provide the video with its appeal to the commission, but I cannot agree to rehear the case for it because it does not show the claimant breaking anything, and it would be a waste of resources to hear the case for video that will not change the outcome. The employer's evidence is insufficient to establish misconduct. Affirm the AT, no misconduct, chargeback.
I concur with Commissioner Dimerson.
Thank you. We will rehear the case and resubmit.
case number 2539916. Commissioner Alvarez,
The decision should be modified to close the ineligibility effective May 30th, 2020. The claimant is a high school student. His semester ended on May 30th. The claimant provided a fact-finding statement to TWC on May 13th, informing us that his semester would end on May 30th. There is no reason to continue holding the claimant ineligible after he became available for work, full-time work, especially in light of how difficult it can be for parties to call TWC. Therefore, AT decision should be modified. The claimant was unavailable for work beginning April 26th. However, the ineligibility should be closed effective May 30th, 2020, which is when he became available for full-time work.
The AT decision should be modified. I agree that the claimant was unavailable for work beginning April 26, 2020, since he was a high school student at the time and was not available for full-time work. However, the closure date should be modified to end as of May 30th, 2020, since that is the date the claimant graduated high school and became available for full-time work. Accordingly, we should modify the AT decision, claimant unavailable for work from April 26, 2020 through May 30th, 2020.
Modify the AT, claimant not available for work April 26, 2020 through May 30, 2020.
Thank you. We have a unanimous decision.
case number 2560595. Commissioner Alvarez,
The AT decision is not supportable. First of all, the AT decision should be modified to impose a ruling that the claimant filed a valid claim as an unemployed individual. On the separation, the claimant stopped working or earning wages when the employer shut down its office for spring break. She was involuntarily separated for reasons other than misconduct connected with the work. Reverse the AT, valid claim, no misconduct, chargeback. In the alternative, even if it's concluded that the claimant was separated when she did not return to work after spring break, the claimant should nevertheless be qualified for benefits. The claimant did not return to work because she is 65 years old and suffers from asthma. Her age, her health condition, and the type of office she worked in made it very susceptible to becoming very ill or dying if she contracted COVID-19. She therefore left the job due to urgent, compelling, and necessary circumstances. Reverse the AT, valid claim, no voluntary leaving due to urgent, compelling, and necessary, no chargeback due to disaster.
And the AT decision should be modified. I agree that the claimant filed a valid claim. As to the job separation, the claimant should be qualified under section 207.046A1 of the Act. The claimant's work as a dental assistant coupled with her underlying health condition and the unknowns at the time regarding the COVID-19 virus made her resignation urgent, compelling, and necessary. Thus, the claimant should be qualified for benefits and the employer should be protected from charge. However, based on the claimant's testimony, a memo should be sent to investigate the claimant's availability for full-time work. We should modify the HT decision, valid claim, no voluntary leaving, no chargeback, separation was urgent, compelling, and necessary. Set aside the adequate response ruling, the correct erroneous AT ruling, and send a memo to UIO and CS to investigate the claimant's availability for work.
I concur with Commissioner Jamerson.
Thank you. You
Sherry,
have,
one moment, Sherry.
yes, sir. Go ahead, sir.
All right, Sherry, we're good.
All right. The majority vote that I have documented is valid claim, claimant left work, urgent and compelling, chargeback employer protected, set aside AR, adequate response ruling, and memo to UIO and CS on availability.
I believe Commissioner Jamerson had also a correction to the AT ruling.
Commissioner Demerson?
Yes, correct erroneous AT ruling. That was a part of it as well.
Right. I believe the erroneous AT ruling is the validity of claim ruling that was missing. So by voting valid claim, you have corrected the appeal tribunal decision.
Okay, that makes sense.
Thank
Ms.
you.
Miller, I will agree with the commissioners.
Thank you very much. We have a unanimous decision.
Case number 2563303. Commissioner Alvarez.
The AT decision should be reversed. The claimant was a 73-year-old lady, correction, 73 years old, and is immunosuppressed and worked in a healthcare facility. She was at high risk of serious illness or death if she contracted COVID-19. She therefore left the job due to urgent, compelling, necessary circumstances. Reverse the AT, no voluntary leaving due to urgent, compelling, and necessary, no chargeback due to disaster.
The appeal tribunal decision should be modified. The claimant quit her job due to fear that she might contract COVID-19 at the workplace. The claimant provided testimony indicating that she was at a higher risk of getting sick from COVID-19 based on age and an underlying health condition. As such, the claimant initiated the job separation, but under circumstances that were urgent, compelling, and necessary. Thus, the claimant should be qualified for benefits and the employer's account should be protected from charge. We should therefore modify the AT decision. No voluntary leaving, no chargeback, separation was urgent, compelling, and necessary.
Modify the AT, no voluntary leaving, no chargeback, urgent.
Thank you. We have a unanimous decision.
Case number 2563486. Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant initiated the job separation when she failed to seek and accept further teaching assignments, which were available every day. It was the claimant's responsibility to use the online portal to find and accept assignments. Substitute teachers were not required to wait for the employer to contact them when they were needed. In the absence of any reason for the claimant's quitting, good cause to quit has not been shown. Accordingly, we should reverse the AT decision, reimburse an employer, not bill.
The decision should be affirmed. The claimant was working on call as needed and did not know at the time her last assignment ended when her next work day would be. The employer's witness could not say with certainty when work was next available to the claimant and failed to produce any documentary evidence of available work. Affirm the AT bill reimbursing employer.
Reverse the AT, reimburse the employer, not bill.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2567271. Commissioner Alvarez.
The decision should be reversed. After the claimant submitted a leave request, he wasn't allowed to return to work until 15 days had passed, or the leave request was denied. When the leave request was denied, the claimant contacted HR. The claimant was told by HR that he should resubmit his leave request. He followed the advice from HR and was then again prohibited from returning to work, which caused him to go over the allowable unpaid time off. The employer's leave and blackout policies are complex and a little confusing. Therefore, the claimant's actions of contacting HR and relying on their guidance was reasonable. As following HR's guidance led to his discharge, the claimant should be qualified for benefits. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant was aware of the employer's attendance policy and that a negative attendance balance could jeopardize his job. Nonetheless, the employer testified that the claimant reached negative 50 hours and was fired. Since the claimant was discharged for violation of a known and reasonable policy, his actions constituted work-connected misconduct. We should therefore affirm the AT decision, misconduct, no chargeback.
On the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez, I have your dissent.
Case number 2571752. Commissioner Alvarez.
The decision should be modified. The claimant filed a valid claim. Regarding the job separation, the claimant had a self-quarantine beginning March 12 due to COVID-19. He called in every day as required. However, on March 23rd, he called in 15 minutes late. As the employer was aware that the claimant was required to stay at home for 2 weeks, and since he substantially complied with the employer's call-in policy, the claimant's separation was a result of his medical condition and not misconduct. Modify the AT, modify the decision. Claimant filed a valid claim, no misconduct, no chargeback, MVI.
The appeal tribunal decision should be affirmed. I agree that the claimant filed a valid claim. As to the job separation, the claimant admitted that he was late notifying the employer of his absence. Since he acknowledged that he had received 3 prior warnings for attendance and that he was told his job was in jeopardy for attendance, his failure to properly notify the employer of his absence constituted work-connected misconduct. We should therefore affirm the AT decision. The claimant filed a valid claim, misconduct, no chargeback.
Affirm the AT, valid claim, misconduct, no chargeback.
Short form dissent.
Thank you, Commissioner Alvarez. And that was the last case on docket 35, last UI pulled case.
Here.
Yes, sir.
Here on docket 35, it was case number 5, but appeal number 2524253. It was the 5th case. We had mentioned the short form dissent, and so we're going to just take that short form dissent off the table.
Let me go back. You're talking about the 4th case or the 5th case?
The
5th case. 2524253.
That's correct.
Okay, we'll remove that short form dissent.
Thank you.
All right, then I believe that will conclude the pulled cases on docket 35. You should have the short form dissent list for docket 35 already.
Move we accept staff recommendations on the remaining UI cases on docket 35.
I second the motion except for those cases on which I'm dissenting, as reflected on the UI short form dissent list for docket 35.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the short form dissent list for docket 35.
Motion passes with the exceptions noted.
Thank you.
Let's move to docket 36.
Yes, sir.
Case number 2435141. Commissioner Alvarez.
The commission should rule that the claimant in this case had good cause for his non-appearance at the AT1 hearing. The claimant did not appear for the AT1 hearing in this case because he consulted an attorney and was advised by the attorney not to participate in the hearing. Since the claimant went to the trouble to consult an attorney about the hearing, he made a reasonable effort to participate and would have done so, but for the erroneous advice of his counsel. Grant the MR, claimant, establish good cause for his non-appearance, resubmit the case on its merits.
The claimant's non-appearance at the AT hearing was not due to circumstances in his control. As such, he did not have good cause for missing the hearing. Accordingly, we should vote that the claimant's MR be granted. The claimant did not establish good cause via Rule 17 and leave the prior CA decision in effect. Misconduct, no chargeback, adequate employer response.
Grant motion for rehearing, no good cause for claimant's non-appearance, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir. Commissioner Alvarez, I have your dissent.
Case number 2498821. Commissioner Dimerson.
The employer's motion for rehearing should be granted. The employer has offered new evidence consisting of witness testimony and documentation about the claimant's work performance. The employer was not able to finish some of this evidence earlier because it was not provided to the employer until recently. Furthermore, the employer explained how review of this evidence would show that the claimant misrepresented his work and was not working to the best of his ability. Therefore, because the employer has met all three criteria for a successful MR, we should grant the employer's motion for rehearing.
The motion for rehearing should be denied. The employer admits in their motion that most of the witnesses they wish to provide were not provided earlier because they did not believe they were necessary. This is not a compelling reason not to offer the evidence earlier. The only information the employer asserts was not available earlier relates to an alleged misrepresentation on a report 2 months prior to the claimant's discharge. The claimant was discharged for failing to meet sales goals, and the purported misrepresentation is immaterial to his discharge. The employer has failed to meet the criteria to grant a motion for rehearing. Deny the motion for rehearing.
Deny the motion for rehearing.
All right, I'll maintain my previous dissent, Chair.
Yes, sir. Commissioner Dimerson.
Thank you.
Case number 2501775. Commissioner Dimerson.
The claimant's MR should be denied. Although the claimant's appeal due date falls within the pandemic period, she did not allege experiencing any technical difficulties while attempting to file her appeal. So her appeal should not be deemed timely on that basis alone. Furthermore, the claimant's general distrust with the mail system does not constitute a valid exception to the timeliness rules. Thus, this new information would not change the outcome of the case, and the claimant therefore failed to meet the criteria for a successful MR. As such, we should deny the claimant's motion for rehearing and leave the underlying decision in full force and effect.
The motion for rehearing should be granted. Since the issuance of the commission decision, additional information has been provided to the commission regarding difficulties in receiving documents, providing appeals, and using commission services due to the pandemic. The claimant's appeal to the appeal tribunal was 1 day late because she had difficulty finding a fax machine due to the pandemic. The claimant's appeal period fell during the time when mailing, faxing, and online services were most significantly impacted by the pandemic. Grant the motion for rehearing. Set aside July 30th, 2020 commission decision, deem the claimant's appeal timely, and remand for merits.
Grant the motion for rehearing, set aside the CA decision, reverse the AT, timely claimant appeal, remand.
Short form.
Yes, sir. I have your short form dissent.
Thank you.
Case number 2521362. Commissioner Alvarez.
The claimant's motion to rehear should be granted. The claimant's MR may not contain new information. But since the claimant's prior appeal, TWC now acknowledges that its systems were overwhelmed due to the pandemic during the claimant's appeal timeframe. The claimant would have had limited ability to view the determination due to the UBS being overloaded, and limited ability to appeal for the same reason. Grant motion to rehear, deem timely, and remand for merits.
Since the claimant did not meet the three criteria for a successful MR, it should be denied. We should therefore deny the claimant's motion for rehearing.
Deny the motion for rehearing.
Mr. Chairman, did you vote to deny?
Yes.
Thank you.
Ms. Miller, short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2526907. Commissioner Alvarez.
The decision should be affirmed. The claimant was asked to perform temperature checks of individuals entering the employer's building. As an armed security guard, taking temperatures was far outside the claimant's job duties. The claimant refusal to take temperatures was not misconduct connected with the work. Affirm the AT, no misconduct chargeback.
The appeal tribunal decision should be reversed. The claimant was notified that he would need to start performing new job duty. The employer testified that it provided the claimant and other security guards with PPE consisting of face mask and latex gloves. Nonetheless, the claimant refused to carry out his job duty, which consisted of using a non-contact thermometer gun to conduct temperature screening on individuals entering the facility of the employer's client. The claimant also admitted to not addressing his concerns with anyone beyond his supervisor. Instead, the claimant opted to be suspended, which eventually culminated in a termination. Since the claimant refused to comply with the reasonable employer directive, his actions constitute misconduct connected with the work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2528461. Commissioner Dimerson.
The appeal tribunal decision should be affirmed. The claimant submitted a 2 weeks or less notice of resignation to the employer. The employer treated the day that the claimant tendered her resignation as her last day with the company, which was the equivalent of accepting her resignation early and at its convenience. Since the claimant provided the employer notice of intent to resign by a definite date 2 weeks or less in the future, the separation in this case should continue to be analyzed as a voluntary quit. Next step is to determine whether the claimant had good cause connected with her for quitting. She did not. The claimant decided to provide a resignation letter to the employer due to her dissatisfaction with receiving a reprimand. In the appeals policy and precedent manual, appeal number 2888-CA-76, held in part that it should be regarded as a necessary incident of the employer's authority that he be permitted to reprimand employees for their failings. Furthermore, an employer should, within reason, even be permitted to enter an erroneous reprimand without the latter necessarily providing his reprimanded employee with good cause connected with the work for resigning. The reprimand in this case before us dealt with manipulation of the work schedule, and the employer was responsible in its desire to enforce the policy. Even if the reprimand is considered to have been erroneous, there is no evidence to establish that it was presented to the claimant in humiliating or accusatory language in the presence of the general public. As such, the claimant quit without work-connected good cause, and we should affirm the AT decision, voluntary leaving, no chargeback.
The decision should be reversed. The claimant submitted her resignation because she was reprimanded by her supervisor for taking a day off. Text messages and evidence indicate the claimant had approval for the time off. The employer's unreasonable reprimand provided the claimant with good cause to quit her work. Reverse the AT, no voluntary leaving chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir. Commissioner Alvarez, I have your dissent.
Case number 7537962. Commissioner Alvarez.
The claimant
Excuse me. Let me just double check that number. Is it case number 2537962?
That is correct. That's what I have written.
2537962. Commissioner Alvarez?
Yes, ma'am. The claimant worked 2 part-time jobs before filing her claim. During the 2 weeks at issue in this case, despite not working, the claimant was paid for 27 hours by one of her employers. The claimant's earnings were adjusted in accordance with the amount, thereby reducing her entitlement to benefits. The determination of the claimant's customary full-time hours must include their hours on all part-time jobs. Therefore, as the claimant was not actually working and was not working her customary full-time hours, she should not be held ineligible for benefits. The decision should be reversed. The claimant is eligible for benefits for the period of May 3rd through May 16th. In the alternative, as the claimant was not questioned about her other part-time job, a rehear would be appropriate.
All right, the commission should grant a rehearing in this case. The record was not fully developed on the issue of the claimant's secondary job with another employer. Since this could affect the analysis of whether the claimant worked her customary full-time hours, we should conduct a rehearing for testimony from the claimant regarding her secondary job. This should include testimony about whether any hours were worked with that secondary job, and if so, the dates so covered by those hours worked.
Agree here.
Thank you. We have a unanimous decision. We'll rehear the case.
Case number 2548558. Commissioner Dimerson.
The appeal tribunal decision should be modified. The claimant's absences during the final days of his employment constituted the reason for separation. The claimant testified that he told the Texas Workforce Commission he was fired because his son had a fever and the coronavirus stay-at-home order was issued. The claimant also provided a fact-finding statement that he was quarantined due to his son having a fever and the coronavirus stay-at-home issue that was issued. The claimant also submitted a text message that he had been practicing stay-at-home order by the county. In sum, there appears to be sufficient evidence to support the claims examiner's initial determination that the claimant separation was due to the disaster. As such, the claimant should continue to be qualified for benefits and the employer's account should be protected from charge. We should modify the AT decision, no misconduct, no chargeback, separation due to the disaster.
I would agree to that.
Agreed.
Thank you. We have a unanimous decision.
Case number 2548641. Commissioner Alvarez.
The decision should be reversed. The claimant was at work on the night shift when he was told that his 4-year-old daughter was ill. The claimant tried to find a supervisor to provide notice that he was leaving to care for his daughter, but he could not find the supervisor. The claimant informed his coworker that he was leaving. The claimant left and took his daughter to the emergency room. The claimant provided TWC the medical documentation showing that he took his daughter to the emergency room. It was not misconduct for the claimant to leave to care for his ill child. Modify the AT, no misconduct, no chargeback, MBI.
The AT decision should be affirmed. The parties agree that the claimant left work without permission, without notice to his supervisor, and without clocking out as required by the employer's known policy. Since the evidence established that the claimant mismanaged his position of employment, we should affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Commissioner Alvarez.
Did I
You
hear
haven't-
again the chairman's his result?
The majority vote that I have recorded is misconduct, no chargeback.
Okay. Short form dissent?
Thank you, sir.
Yes, ma'am.
Case number 2549336. Commissioner Alvarez.
The AT decision in this case should be modified. I agree that the claimant filed a valid claim as an unemployed individual. On the separation, the claimant worked in an environment in which it was impossible for employees to social distance, and the claimant suffers from high blood pressure and coronary artery disease. The claimant's health conditions place him at risk for serious illness or death from COVID-19. His decision to stop working during the pandemic constituted a non-disqualifying involuntarily separation because of urgent, compelling, and necessary circumstances. Modify the AT, valid claim, no voluntary leaving due to urgent and compelling.
Decision should be modified to qualify the claimant under section 207.046A1 of the Act. Claimant's work, coupled with his underlying health conditions and the unknowns at the time regarding the COVID-19 virus, made his resignation urgent, compelling, and necessary. We should therefore modify the AT decision, no voluntary leaving, separation with urgent, compelling, and necessary, and sever the valid claim issue.
I concur with Commissioner Demerson.
Thank you. We have a majority vote on the separation. We will sever the validity of claim issue. Next case, please.
Case number 2555831. Commissioner Dimerson.
We should deny the claimant's motion for rehearing. The claimant provides no new evidence regarding his late appeal. Because the claimant fails to address the jurisdictional issue, we should deny his motion and leave the underlying commission decision in full force and effect. Even if we grant the motion and review the merits of the claimant's late appeal, we should affirm the appeal tribunal decision. While the claimant alleges that he filed his first of two appeals in mid-April, our records indicate that the claimant filed his first appeal in May and his second appeal in June. Both appeals are late to the determination in question. Furthermore, the claimant did not review his TWC inbox until after the appeal deadline had passed and did not allege experiencing any technical difficulties while trying to access TWC. In fact, the claimant testified that his failure to file a timely appeal simply still stemmed from his choice not to appeal. Thus, because the claimant's appeal does not fit any of the timeliness exceptions in our rules, we should grant the motion for rehearing, set aside the commission decision, and affirm the AT decision. The claimant filed a late appeal, misconduct, no chargeback.
The motion for rehearing should be granted. Since the issuance of the commission decision, additional information has been provided to the commission regarding difficulties providing appeals and using commission services due to the pandemic. The claimant testified he submitted an appeal in mid-April without receiving a response. The claimant's first appeal would have been during the time appeals and commission services were most significantly impacted by the pandemic. The commission decision should be set aside and the claimant's appeal deemed timely. Regarding the job separation, the evidence establishes the claimant was discharged for sitting down on the job. The employer admitted the claimant was entitled to take a break while on the clock, and the claimant was not asked if he was on his break when he was discharged. The employer has failed to present sufficient evidence to establish misconduct. Grant the motion for rehearing, set aside the August 6, 2020 decision, deem the claimant's appeal timely, no misconduct, chargeback.
Grant the motion for rehearing, set aside the CA decision, reverse the AT, timely claimant appeal, no misconduct, chargeback.
Sure. Short form.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2556227. Commissioner Alvarez.
The decision should be modified. The job separation ruling is in the claimant's favor and should be severed. Regarding the reporting issue, the claimant testified that he repeatedly called TWC, but was unable to get through due to the high call volume. As the claimant was prevented from reporting due to TWC systems being overwhelmed, the reporting ineligibility should be reversed. Modify the AT decision, reporting eligible, and sever the job separation ruling.
The AT decision should be modified. On the reporting issue, although the claimant initially had difficulty contacting the agency by phone, he has yet to furnish the requested information, despite having the opportunity to do so both during and after the AT hearing. Until the agency receives the necessary wage information from the claimant, the ineligibility should remain open. Accordingly, we should modify the AT decision, reporting not eligible beginning May 31st, 2020, sever the job separation and chargeback issues.
Modify the AT, reporting eligible, sever the favorable job separation issue. Memo to IO and CS to investigate unreported earnings.
Short form, Sherry.
Yes, sir.
Case number 2558340. Commissioner Alvarez.
The decision is not supportable. The employer asked the claimant to sit with a COVID-19 positive patient. The claimant refused. The claimant testified that she was not provided proper PPE to sit with the patient. The claimant also testified that she was expected to do this for 12 hours straight with no relief. The employer provided no testimony regarding either of these issues. The case should be reheard to obtain additional testimony.
We should modify the appeal tribunal decision. First, I agree that the claimant filed a valid claim. As to the job separation, the claimant admitted that she had been warned that if she refused to work with a COVID positive patient again, that she could be fired. After the claimant's first refusal, the employer followed its policy and provided the claimant with training which addressed her concerns. Because the claimant again refused to perform her job duties and was loud, disruptive, and used profanity During the final incident, the claimant was insubordinate and mismanaged her position of employment. We should modify the AT decision. The claimant filed a valid claim, misconduct, void reimbursement ruling, correct the erroneous ruling in the AT decision, plus send a memo to UIO and CS to investigate unreported earnings.
Modify the AT, misconduct, void reimbursement, valid claim, correct errors in AT decision, memo to UIO and CS to investigate unreported earnings.
Long form dissent.
Yes, sir. I have a long form dissent for you, Commissioner Alvarez.
Case number 2560045. Commissioner Dimerson.
We should reverse the appeal tribunal decision regarding timeliness. The employer's appeal was 1 day late due to the unprecedented number of claims the employer received and was working to process. In addition, a large part of the appeal period overlapped the period of time during which TWC was experiencing technical and system outages due to claim volume. When processing so many claims, this no doubt caused some delays. On docket 33, in appeal number 2552575, a claimant who chose not to appeal until almost 4 weeks after the deadline received a majority vote for a timely appeal. If claimant appeals are being deemed timely in cases where they are not choosing not to appeal, then employer appeals should be deemed timely when they are at least making the effort to process the hundreds, if not thousands of claims they have received. We should not have one standard for claimants and another for employers. Therefore, in line with our recent decisions, we should find the employer's appeal timely and resubmit for merits testimony.
The decision should be affirmed. The employer testified they received the determination in question, but did not appeal until after the deadline because they were prioritizing other claims. Affirm the AT, late appeal, employer billed.
The employer's unemployment representative's failure to complete the services for which they contracted with the employer to perform does not establish a timeliness exception. Affirm the AT, untimely employer appeal, bill reimbursing employer.
Short form dissent.
Thank you, Commissioner Dimerson. I have your short form dissent.
Thank you.
Case number 2561860. Commissioner Alvarez.
The AT decision should be reversed. The claimant was let go by the employer when he was absent from work. The claimant was absent from work after he was arrested due to an error made by an Oklahoma court clerk. He was eventually released and no charges have been filed against the claimant. Appeal number 2622-CA-76 in the Appeals Policy and Precedent Manual states, an employee arrested unlawfully and for which he has not been found guilty does not commit misconduct connected with the work. The claimant in this case made every effort available to him to keep the employer informed of his absences, and his absences were caused by circumstances beyond his control. Pursuant to commission precedents, the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct chargeback.
We should affirm the appeal tribunal decision. The claimant missed several days of work without proper notice to the employer because of his incarceration. Because the claimant had the opportunity to properly notify the employer of his absence and failed to do so, the claimant mismanaged his position of employment. We should affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir. Commissioner Alvarez, I have your short form dissent.
Thank you.
Case number 2562011. Commissioner Dimerson.
We should reverse the appeal tribunal decision regarding timeliness. The employer's appeal was 2 days late due to the unprecedented number of claims the employer received and was working to process. In addition, a large part of the appeal period overlapped the period of time during which TWC was experiencing technical and system outages due to the claim volume. When processing so many claims, this no doubt caused some delays. Again, on docket 33 in appeal number 2552575, a claimant who chose not to appeal until almost 4 weeks after the deadline received a majority vote for a timely appeal. If claimant appeals are being deemed timely in cases where they are choosing not to appeal, then employer appeals should be deemed timely when they are at least making the effort to process the hundreds, if not thousands, of claims they receive. We should not have one standard for claimants and another for employers. Therefore, in line with our recent decisions, we should find the employer's appeal timely and resubmit for merits testimony.
The decision should be affirmed. The employer's third-party representative filed a light appeal. The representative did not allege a timeliness exception and did not allege that the appeal was late due to any issues with TWC's receipt of the appeal. As such, the employer's appeal should be dismissed as late. Affirm the AT late employer appeal, bill reimbursed employer.
The employer's unemployment representative's failure to complete the services for which they contracted with the employer to perform does not establish a timeliness exception. Affirm the AT untimely employer appeal, bill reimbursing employer.
Short form dissent, Chair.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2562074, Commissioner Demerson.
We should reverse the appeal tribunal decision regarding timeliness. My comments are the same as the previous cases, that the employer appeal was 2 days late to the unprecedented number of claims the employer received process. If claimant appeals are being deemed timely in cases where they are choosing not to appeal, then employer appeals should be deemed timely when they are at least making the effort to process the hundreds, if not thousands, of claims they've received. Claimant and employer should be held to the same timeliness standards, and accordingly, in line with our recent decisions, we should find the employer's appeal timely and resubmit for merits testimony.
The employer's third-party representative testified they prioritized responding to other types of claims and filed a late appeal in this case. This does not fit a current timeliness exception, and the third-party representative delay was not caused by TWC. As such, the appeal should be dismissed as late. Affirm the AT late employer appeal, bill reimbursing employer.
Employer's unemployment representative's failure to complete the services they contracted with the employer to perform does not establish a timeliness exception. Affirm the AT untimely employer appeal, bill reimbursing employer.
Short form dissent, Chair.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2562643, Commissioner Alvarez.
The claimant's appeal in this case should be deemed timely. Commission records show that the appeal in this case was filed 1 day after the stated deadline at the AT decision. However, there has been difficulty recently in ensuring that commission correspondence has been mailed on the date indicated. As a result, the commission has made it a policy to deem timely appeals that are on their face 1 day late. It is uncertain whether the AT decision in this case was actually mailed on the date indicated, and the claimant's appeal should therefore be considered timely. Deem commission appeal timely and resubmit the case on merits.
The claimant did not allege an exception to the timeliness rules, and the appeal period fell outside of the pandemic period. There is no basis by which the claimant's appeal can be deemed timely, and we do not have jurisdiction to consider the underlying merits of this case. As such, we should dismiss the claimant's appeal as late and leave the underlying AT decision in full force and effect.
Timely commission appeal, resubmit.
Thank you. We will resubmit the case.
Case number 2563402, Commissioner Demerson.
We should modify the appeal tribunal decision. First, I agree that the claimant filed a valid claim. As to the job separation, the claimant was separated due to lack of work resulting from the COVID-19 natural disaster. Thus, the claimant should be qualified for benefits, and the employer's account should be protected from charge. We should modify the AT decision. The claimant filed a valid claim, no misconduct, no chargeback, disaster.
Ms. Miller, will you let me consult real quick?
Certainly.
Okay. Ms. Miller, I would agree with Commissioner Demerson.
Thank you.
I concur with Commissioner Jefferson.
Thank you. We have a unanimous decision.
Case number 2564547, Commissioner Alvarez.
The decision should be reversed. The employer did not appear to offer testimony and evidence. The claimant quit her assignment because she was working in a group setting with other people and no one was being required to wear a mask. The claimant quit because she lives with two people who are at risk due to severe illness if they get the coronavirus. The claimant had good cause connected with the work for quitting. Reverse the AT, no voluntary leaving, no overpayment.
I would agree to the claimant under section 207.046A1 of the Act. Based on the facts of this case, accordingly, we should reverse the AT decision, no voluntary leaving, separation was urgent, compelling, and necessary, no overpayment.
I will concur with Commissioner Jefferson.
Thank you. And that was the last pulled unemployment insurance case on docket 36. You should have received the short form dissent lists for docket 36.
And Sherry, before we move on, let me, I want to revisit one of the other cases that we had under docket 36, okay?
Yes, sir. Which case number? Didn't, okay, I'll wait.
Okay, thank you.
Yes, sir.
Here, so I'd like to go, it's case number 8 on docket 36, not case number 8, but number 8. And the appeal number is 2548558. So docket 36, 8, appeal number 2548558.
1 moment.
Okay,
Apologize. I need to find the page.
okay.
One moment. I apologize. It made its way to the bottom of the stack. All right. And what would you like to change?
So the vote will remain the same. What I like to add on, so it's no misconduct, no chargeback, separation due to disaster. But I wanted to add that the claimant filed a valid claim. Claimant filed a valid claim.
Okay. Got it.
That's it.
All right. Then I believe it's time for the short form dissent motion.
This is the list we've received. I move we accept staff recommendations on the remaining UI cases on docket 36.
I second the motion except for those cases on which I'm dissenting, as reflected on the UI short form dissent list for docket 36.
And I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected on the UI short form dissent list for docket 36.
The motion passes with the exceptions noted.
Thank you very much.
Thank you. And this brings us to the end of agenda items 3 through 7. We're going to pause for a few minutes to reset the rest of the meeting. right, gentlemen, are we ready to proceed with the rest of this?
Yes, Chairman.
All right, thank you. We're going to move to agenda item 8. This is discussion, consideration, possible action regarding publication, public comment of proposed rules relating to the 40 Texas Administrative Code, 40 Chapter 5, House Bill 3, enacted by the 86th Texas Legislature.
Good morning or good afternoon, Chair Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Serna. For the record, my name is Fabiana Ramirez, Program Specialist with Adult Education and Literacy. House Bill 3, 1949, and House Bill 3, both enacted by the 86th Texas Legislature regular session, require TWC to develop rules to implement legislation. And staff at the time proposed developing these rules in chapters 800, 805 of the Texas Administrative Code. House Bill 1949 introduces an AEL performance measure related to enrollment and credential achievement in high school equivalency programs or post-secondary ability to benefit programs that must be included in TWC's AEL performance-based funding criteria. On October 8, 2019, the Commission approved the implementation of House Bill 1949, adding that criteria for performance-based funding as outlined in the legislation. Staff proposed developing rules in Chapter 800 as shown in Item 8A of the notebook materials to define ability to benefit, outline the performance criteria in House Bill 1949, and create a rule that requires the Commission to approve milestones toward meeting criteria each program year. Additionally, proposed rule language states the Commission will review and approve the award of AEL grant funds to be issued as required in House Bill 1949. Section 1.046 of House Bill 3 required TEA, or Texas Education Agency, to enter into an MOU with TWC when transferring funds to provide a subsidy for the cost of a high school equivalency exam for individuals who are 21 years of age or older. House Bill 3 also requires TWC to develop rules addressing eligibility requirements for individuals participating in the program. Staff proposed developing rules in Chapter 800 to describe this MOU, also reflected in notebook material item 8A, and to create a new subchapter in Chapter 805, shown in item 8B of your notebook materials, entitled High School Equivalency Subsidy Program. As the implementation of both House Bill 1949 and House Bill 3 began prior to final rule adoption, the policy concept for this rules development was posted as a notice in the Texas Register for a 30-day comment period, which ended May 11, 2020. Staff addressed the comments received during that period as reflected in the proposed rule documents in your notebook materials. At this time, staff seeks direction on approving proposed rules for Chapter 800 and 805 to be published in the Texas Register for a 30-day comment period, as reflected in notebook materials 8A and 8B, to implement House Bill 1949 and House Bill 3. Thank you. That concludes my remarks, and I'm available to answer any questions you may have.
Comments or questions?
None here, Chairman.
None.
All right, do we have a motion?
I move that we publish the proposed rules to amend Chapter 800 and 805 relating to the AEL program to the Texas Register as discussed.
I second the motion.
It's been moved and seconded, and we're unanimous. Thank you.
All right, thank you.
This will bring us to agenda item 9, discussion, consideration, possible action regarding publication for public comment of proposed rules relating to the repeal of 40 TAC Chapter 841 and new 40 Chapter 840, new TAC Chapter 842, and new TAC Chapter 40 TAC Chapter 802.
Hi, good afternoon, Chair Daniel, Commissioners, Mr. Serna. For the record, my name is Joel Mullins with the Workforce Development Division. TWC's Chapter 841 Workforce Investment Act rules set forth provisions related to the maintenance of a one-stop delivery system, training provider certification, non-discrimination and equal opportunity, and appeals of denial of local workforce development area certifications. On March 17th of this year, the Commission approved a policy concept outlining the repeal of Chapter 841 to eliminate rules that are specific to implementation of the Workforce Investment Act and to update and maintain in new and existing chapters elements of Chapter 841 that remain relevant to agency operations. This policy concept was posted to TWC's website for a 3-week board comment period, and no comments were received. This afternoon, staff seeks direction on proposed amendments for publication in the Texas Register for the following chapters as provided in your meeting materials. Repeal of Chapter 841, the Workforce Investment Act, new Chapter 840 on eligible training providers, new Chapter 842 on WIOA non-discrimination and equal opportunity, new Chapter 802 Subchapter J, local workforce development area appeals. Staff would like to be able to make non-substantive technical corrections prior to submission to the Texas Register. And I'll be happy to answer any questions you have.
Comments or questions?
Chairman, I do have comments. Joel, thank you for the briefing. I have concerns with the proposed language for section 840.64 regarding out-of-state training providers. We need to keep Texas training dollars in Texas to ensure that our training dollars provide an economic benefit to the state by investing in our training providers and training Texas residents. If we allow these funds to go out-of-state providers, there's a strong likelihood that Texas will lose full benefit of these dollars. Additionally, as we have many available training providers for any in-demand occupation, there is not a need for out-of-state training providers, and this provision is not required by WIOA. By removing this section, we will also provide consistency with our other training programs. I'd ask my fellow commissioners to consider delaying action to provide staff with an opportunity to address this issue.
Are there any time frame restrictions? Are we up against a clock of any sort with this this item?
No, I don't think so. Other than just wanting to get the rules adopted before session begins. But I think staff can certainly go back and look at that and bring these 4 rules back in the next couple of weeks. I don't think that won't cause us any timing issues. I don't think.
Commissioner Alvarez?
Yes, sir.
So your issue in Chapter 840 noted, but in the other 3 rural packages, these are just going to the Texas Register. Do they need to be delayed in order to address this issue in Chapter 840?
Chairman, I think that they do, simply because the Chapter 841 currently includes some provisions related to eligible training providers. If we repeal that chapter without, well, I guess it's not. Okay, so no, I think we could go to the Texas Register and go through the public comment process, but we wouldn't want the final rules to be adopted before we also adopted the new eligible training provider chapter.
Yeah, I think, commissioners, for us, the question is do we proceed on the other 3 and this one back so that staff can address this issue per Commissioner Alvarez's request, or do we just hold back on the 4 while we work on 840? I guess I'm signaling that I'm inclined to provide some amount of time for Commissioner Alvarez to address his concern. We probably do need to get a motion before us so we can take action on that, but sort of gauge where we are with this.
So, Mr. Chairman, repeat what you just, not the entire thing, what you just said, but that first portion of it.
Well, I was speaking off the cuff, so I will try to duplicate it as best.
You're inclined to do, what were you inclined to do?
Well,
let me ask this, Joel. Are the chapters interrelated? That would be my question.
Yes. So we're recommending the repeal of Chapter 841 and new Chapter 840. The one that you're about is some of the language is coming from the 841 that is being repealed. So they are interrelated. Yes.
So Chairman, that's the only reason that I would want to bring them all back at the same time, only because of that reasoning.
Okay. Do we have a motion on this? I would agree to delay consideration. That probably wouldn't require a motion. Ed, would you agree?
Right. Yes, sir. I was going to say, it sounds like it's just no action on this agenda item. We'll bring it back to the commission in the next couple of weeks after we're able to do some research and represent it to the commission offices.
All right. So not the next commission meeting, but the commission meeting after that. So that'd be,
Yes, sir.
what will that be? The 22nd?
I believe so. Yes, sir. Before the end of September.
Let's get it on the agenda for September 22nd. And I'm just doing a little administrative paperwork here. So chapter 841, the repeal, and then there were chapter 840, which is where we're talking about out-of-state providers. Does this impact the chapter 802 change on local workforce development area appeals?
That section or that subchapter that we're adding to chapter 802 is coming directly from the chapter 841 repeal. It is not in any way related to the chapter 840.
Well, can it move out today, or do you just want to sit on it until 2 weeks?
Mr. Chairman, I'd recommend that we just sit on them all and bring them all back at the same time. Though I don't believe that one is affected by the delay, I think it would be cleaner for us just to bring the entire package back at the same time.
Okay, I don't have an issue with that. Commissioners, is this acceptable to everyone?
Yes.
Thank you,
Yes.
Chairman.
Okay.
Thank you, Joel.
very much.
Okay,
Thank you
great.
for that.
Thank you.
This will bring us to agenda item 10. Discussion, consideration, possible action regarding the funding distribution methodology for reemployment services and eligibility assessment program.
Good afternoon, Chair Daniel, Commissioner Alvarez, Commissioner Demison, and Mr. Cerna. For the record, my name is Dawn Cronin, Director, Workforce Program Policy. The Reemployment Services and Eligibility Assessment, or the RESEA program, is now a formula-funded program. And as such, TWC is required to distribute these funds to boards based on the formula fund distribution under which the funds were received. All boards will receive a base distribution of 25% of the available funding. Under the formula distribution methodology, boards will receive an additional 75% of available funding based on their insured unemployment rate. The base distribution ensures each board has enough staff and resources to operate the program, as well as funds to provide the required services to the growing number of UI claimants. Under the updated distribution formula, boards will receive an overall increase in funding. Staff is asking for consideration and approval of the updated distribution methodology to align with the formula fund distribution requirement. I'm happy to answer any questions you might have.
Any comments or questions?
None here, Chairman.
None.
Do we have a motion?
I move that we distribute a base funding level of 1/28 of 25% of funds available for RESEA for distribution to each of the workforce areas, and the remaining 75% be distributed based on the workforce areas, insured unemployment rate as discussed by staff.
A second.
Been moved and seconded. We're unanimous. Thank you.
Thank you, sir.
This will be agenda discussion, consideration, possible action to adopt the Texas Workforce fiscal year 2021 budget 22-23 legislative appropriations request.
Good afternoon, Chairman, Commissioners, Mr. Cerna. For the record, Chris Nelson, Chief Financial Officer. You have before you a document listing the 2022-2023 capital budget and exceptional items as part of our upcoming LAR submission. Page 2 of the packet lists our base requests of capital budget by the funding type. Included in items are PC refresh for agency desktops and laptops, continued support for work in Texas, and our data center consolidation budget with the Department of Information Resources. This base request totals $109 million over the biennium, and it should be noted that our DCS budget makes up approximately $81 million of that request. Starting on page 3, you see the exceptional items for our capital budget. The total amount of our exceptional request is $29 million, of which $6,500 is general revenue and $11,000 is general revenue dedicated. The items as part of that exceptional item request include $13.6 million to replace our legacy vocational rehab case management system and monitoring systems, $13.2 million to replace our child care case management system, $236,000 to replace our work opportunity tax credit system, $602,000 to replace our foreign labor certification application system, $930,000 to update TWC agency website, and $350,000 for enhanced communication efforts with our TWC customers. This solution would provide enhanced communication capabilities, such as the ability to text customers. Two other items listed are the Twist system replacement and the UI system replacement. These items were approved last session, but TWC fully anticipates these projects to continue past 2022 when the capital appropriation expires. We will submit a rider request as part of our LAR to move any unspent funds into 2023 for these projects. If that is not approved, we will request LBB to add these items to our capital exceptional items for 22-23. That concludes my remarks. I would be happy to answer any questions, or if any commissioner would like to add any other exceptional item.
Any comments or questions?
Chairman, I do have a comment.
Yes.
So Chris, great presentation, and thank you for the overall explanation on agenda item 11. Commissioners, I have one exceptional item request that I'd like to present today. I would like to propose $1.5 million of GR for the development and implementation of both youth and adult pre-apprenticeship career pathways into registered apprenticeship training programs. Texas Education Code Chapter 133 statute allows for pre-apprenticeship training leading to related classroom training for apprentices. Apprentices are full-time paid employees in the private sector, impacting not only the apprentice life, but the Texas economy. Pre-apprenticeship places both youth and adults in career pathways with built-in advancement to salaries in excess of $60,000 plus annually. Pre-apprenticeship can be a key in preparing both youth and adults for highly skilled, highly paid careers in a wide variety of industries and their apprenticeship occupations. Prior to COVID, industry partners were competing for entry-level workers to develop into seasoned workers. Since COVID, more of the workforce is looking for entry-level positions with significant career pathways and opportunities. Pre-apprenticeship offers that pathway and opportunities. In the first year, I would like the allocation to be $500,000 in 2022 and $1 million in 2023. Dividing up the funding in this manner would allow our apprenticeship team to ramp up. That ends my comments.
Okay, additional comments or questions?
Yeah, just going back, Chris, you had mentioned the rider request that we'll seek. And if we don't receive that, then we'll look to have LBB add this as an exceptional item. The ones that you mentioned prior to Commissioner Alvarez's comments there. What are the timeframes? Like when the rider request, when is that requested, and when would we know?
So the entire thing will be submitted as part of our LAR request on October 9th, just as we're doing today. That the rider revisions that we'll kind of present to the commission will be in one of the subsequent meetings between now and then. So we have the 15th, I believe the 29th, and then the 6th. So in one of those 3 meetings, you'll get a packet with staff recommendations for rider, which this would be one of them.
Okay. And so we'll have that request, and if that's not accepted, then we'll look at LBB to list that as accepted.
Yes, once session starts, if it's not approved, that rider revision, then we will ask LBB to add those 2 items, any unspent or any unprojected unspent amount, to our capital requests for 22 and 23.
Okay, good, because that is
continue past that.
Yeah, that's
again.
that assists with our whole UI system replacement.
Yes.
Okay. 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 That's all, Mr. Chair.
If there's no additional comments or questions, do we have a motion to consider?
Yes, sir. I move that we approve the 2022-2023 LAR capital and exceptional item budget requests, including the exceptional item budget request to expand pre-apprenticeship in the amount of 1.5 million as discussed.
Okay. Before we move on with that one, yeah, this additional exceptional item that we're seeking to place in here. So the agency at this point, we don't have any other exceptional items. We've gone into a session where exceptional items are something of there's a priority there. What's our take or just discussion on having an exceptional item listed with what we're dealing with right now? I know the exceptional items that are listed here that Chris has identified are pretty solid. They're not outside of anything. They're not anything new in that regard. I'm asking the legislature for additional appropriations right now. Any sentiments around that from you guys?
Commissioner Demerson, I know that following the 8 exceptional items that Chris laid out in front of us, he did ask the commission if there were any other exceptional items that the commissioners would like to address at the time. And so this was one, and especially during conversations that all of us have had regarding apprenticeship, pre-apprenticeship, and some of the local industries that are moving into Texas, seeing that there's a demand for youth apprentices in the state, a demand for that. And so I thought it was appropriate for me to bring it up at this time since he had requested any additional exceptional items that the commission wanted to take action on.
Okay, and I support the efforts wholeheartedly, especially if employers have a choice around that. I'm seeing some of the details around the program because I'm hearing it or seeing it for the first time. Normally we have some paper somewhere that's provided to us, and not seeing that we're kind of voting on it pretty much without that information. So, but I trust the process and understand the work that's been done in that space is pretty substantial. So I'll go ahead and second, but I look forward to getting some of the information around the program so that we can further advocate on behalf of this exceptional item that's been presented.
And also I'd like to go ahead. I'm sorry, Chairman.
No, please go ahead. I do have a comment I want to make.
I was just going to say that I know that just the listening sessions that I've been able to listen or be a part of, and just the listening portion of the tri-agency meetings have many of those that have outside of the agency have expressed interest in pre-apprenticeship. And so, and again, at our last tri-agency report that we did back in 2015 and had written up in 2016, I should say, it did reference pre-apprenticeship a few times. And so I just want to make it clear that there's a distinction between pre-apprenticeship and CTE courses. And that's just, that's all I'd like to add to that.
Prior to our final vote, I would say I reluctantly I can't agree to the motion, and let me explain why. It has to do with the exceptional item for pre-apprenticeship. While I am very supportive of the program and definitely do want to see it grow into the future, I'm concerned about where reports would tell me the legislature has to begin with the state budget and the availability for funds. And I'm just reluctant to put an exceptional item in our request that is growing a program that we currently have funding for and looking for an expansion to that program. And as much as I support apprenticeship, our efforts at this agency and certainly what private employers are doing with regard to apprenticeships, I feel like it's more prudent for the taxpayers to not ask for the exceptional item time based on my knowledge of where I think the legislature will be in considering the state's budget for the next biennium.
So Chairman, if I may add that, as we know, we don't have a budget right now specifically for pre-apprenticeship. And so all we're asking here is for our legislators to actually consider that. And only brought this up as a result of what we've been experiencing with COVID and again, with some of the employers and some of the discussions that this office has had with a few folks recently. They've all expressed pre-apprenticeship opportunities, interested individuals at an earlier age to start thinking about the trades. And this is a good way to get individuals like that. But again, we don't have a budget, if I'm correct, with the exception of 133 is referenced in here. The 133 allows us to fund pre-apprenticeship, but we have no funding allocated for it as of right now.
Mr. Chair, I mean, my initial raising of this issue is centered around everything that you just mentioned. And basically, we're going into a tough legislative session where agencies are asked to take cuts and the like. And so I think the items that Chris presented initially are solid items that we can stand behind. Anything in addition, it's a heavy lift. I mean, at this time, and I think we may be looking at the will of the legislative body in the sense of things that maybe they're hearing through the tri-agency initiatives as such, and maybe things come from that versus going over at this particular time with an exceptional item from the agency. I'm not sure if we want to make sure we're reading the pulse of what's happening out there right now. And that's an important initiative. I know we have a lot of work that we've done in that space already. And I think we have some opportunities to do even more as we've been, to your words, Mr. Chairman, flexible and nimble and creative, similar to the call that was received earlier from the individual in the childcare space. It's because of the work that the staff has done in the ability of my fellow commissioners to be nimble and flexible to address those needs. But going right now, and it's a small amount, but we're dealing with some serious, interesting times right now, and I think we need to really read that as much as possible. And approaching with an exceptional item is not, I don't think, in the best interest, not that of the program, but I don't think the timing is right to do that.
Look, again, if I may just add I would leave that up to the legislature to inform us that we couldn't do it or fund it. Again, I think there's going to be a lot of activity surrounding apprenticeship programs. This is no guarantee that this is going to happen. It's a request coming from the agency. And again, conversations that we've had with, Fanuc, Tesla, some of the other companies that have all expressed they would like more kids to be focusing on the trades at an earlier age prior and more of a pre-apprenticeship type of training. Things like what Trio Electric has done with Spring Branch. I think this would transform the area where Tesla is going to be located with the local area high school. Those are conversations that have been happening. Again, this is part of the tri-agency initiative. And so, at least in those discussions that I've heard, I haven't been a part of them, but just in those that I've heard, and then I'm only following the report that we submitted or we got back a couple of years back. And then with the success of 2784, that we all had an opportunity to see the young lady specifically throw apprenticeship shout out. Again, this would be funded by the legislature, not by us. But I certainly understand your all's concerns.
Chris? Mr. Cerna, how time sensitive is this?
So
Wait, Chris.
Chairman, I'm sorry, Ed. We have until the 9th to do this. We've broken this process up over several weeks. One, because we got instructions late from LBB, and so we really didn't know what needed to be in the LAR request. And so we specifically broke up, we broke out the statewide initiatives as one piece. This is another piece of capital. So we still have time. I don't need an approval on this today. One of the benefits of breaking this up is that the offices have a chance to kind of review and digest the materials without, being forced to make a decision with the deadline looming. So we've got time if I need to bring this back.
Commissioner Alvarez, at this point, it's on the table. I can move the table this motion and bring it back at the next meeting if that's not a problem for you.
I would be fine with that, Chairman, if that's okay with Commissioner Demerson.
That would be excellent. It would give us an opportunity to kind of look at it and
All right. So technically speaking, I'm moving to table the motion. It's acceptable to the maker of the motion, and we'll consider that a second. This is tabled until the next commission meeting, the next regularly scheduled commission meeting, which will be next week.
And we'll add we'll modify this document for a separate section to include a commission request to lay out kind of what Commissioner Alvarez is asking for.
Very good. Very good. Thank you. All right. Thank you, commissioners.
Thank you, Chairman.
I believe that's all Chris had to offer. There's nothing on agenda item 12, statewide initiatives. Let's move to agenda item 13, special consideration and possible action regarding guidance on resource utilization and implementation of services and strategies to target disaster relief efforts and public health emergency, including those funded with the Department of Labor's Disaster Dislocated Worker Grant.
Good afternoon, Chair Daniel, Commissioners, Mr. Cerna. For the record, Gentrope Workforce Division. On August 27, 2020, Hurricane Laura made landfall on the Texas coast. In response, TWC has applied for and anticipates receiving a $5 million Disaster Dislocated Worker Grant from the U.S. Department of Labor to expedite disaster relief services in 2 workforce development areas. Boards have expressed an urgent need for disaster dislocated worker grant funding to assist with cleanup and humanitarian assistance. These funds will support temporary employment for participants in these 2 local workforce areas. Staff seek direction on approval for $5 million in LAURA funding upon receipt of federal funds to provide $2 million to Deep East and $3 million to Southeast to provide services to LAURA impacted participants. Any questions?
Comments or questions?
None here, Chairman.
None.
All right, let's see. Do we have any motions?
Yes, sir. I move that we approve $5 million in Laura Disaster Dislocated Worker Grant funds to provide upon receipt of federal grant funds, $2 million to Deep East and $3 million to Southeast workforce development areas as discussed by staff.
Second.
That's been moved and seconded. We're unanimous.
Thank you.
Thank you. Do we have any additional items under agenda item 13?
Yes, sir. We have a quick update from Courtney Arbor.
Thank you, Ed. Good afternoon, Commissioners. Courtney Arbor, Workforce Division. I have a couple of updates related to COVID activities here at the state and at the local level. As you know, workforce boards continue to provide services either virtually or in person or a hybrid, reminding everyone that they're open and available to help as people look for work and look for programs that may be of need to them or the students in their family through the youth program. The adult ed and apprenticeship providers also continue to provide their courses virtually or in person or again in some type of a hybrid format. All of these partners have really responded and are making sure that the public knows they're available and that they're open for business, whether virtually or not. The training provided to claimants through the Metrics Learning platform is well underway. All claimants in Texas have now been contacted. So all unemployment insurance recipients in Texas have received an email from us, encouraging them to begin using the more than 5,000 courses that are available to them for building new skills and in new occupations if they're interested in doing that. The vendor Metrics shares dashboard information with TWC so that we are able to gauge the usage. We're able to who has even seen the email, who's logged in, who has started a class. And so recently we started sending some email nudges to claimants, trying to remind them to start if they haven't, finish the courses if they've maybe taken a break. We really want claimants to take advantage of this opportunity while they may have some time. They haven't gone back to work just yet. And since it's no cost, it really is a great resource for them. So we're doing a lot of nudging to get people back in or engaged if they haven't. 26,000 courses have launched at this point with 15,814 completed. And so that's right, more than half of the course launches are successful completions, which we see as a good number to look at. And of course, we want any claimants to keep using that system. We're pushing out information on social media also so that if anyone hasn't seen the email, they know how to contact us. Last just wanted to mention that the 2 workforce call centers are up and running, have been for several weeks, doing a great job. They are contacting claimants, pointing them toward Workforce Solutions office, the specific office in their area, and talking with them about the resources that the local boards and the local service providers make available, and just introducing them to some of the services they can find through our system. They help with job matching and registration and work in Texas. To date, 95,000, little over 95,000 claimants have been outreached. 12,010 have had help with registering and work in Texas and job matching. Those are the primary reasons for the calls. But one of the things we're finding that the call center staffs are also hearing about employment when they contact a claimant. And so that's been really encouraging. We've learned to date, and not everyone wants to share those details, but when they do, it's really exciting for everyone. We've learned of more than 4,200 hires while making those phone calls, which is really encouraging. And of course, we're sharing all of this information with the local workforce boards and coordinating activity with them so that when either of us talk with a claimant, we know what services the other is providing. That's all I have for the update today, but I'm happy to answer any of the questions you might have.
Any questions or comments?
No, Chairman.
None here. Thank you, Courtney.
Thank you, Courtney. Do we have any other items under 13?
No, sir.
Item 14 is discussion, consideration, and possible action regarding approval of local workforce development board nominees.
Good afternoon, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Shanta Williams with the Workforce Development Division. And before you for consideration today, we have workforce board nominees for Workforce Solutions, Deep East, Central Texas, the Coastal Bend, and Texoma. That concludes my request, and I'm here to answer any questions you have.
Any comments or questions?
No, sir.
None.
Do we have a motion?
I move to approve the board nominees for Deep East Texas, Central Texas, the Coastal Bend, and Texoma.
And a second.
Maybe seconded, we're unanimous.
Thank you.
Thank you. We do not have a legislative report today. Mr. Cerna, do you have anything to report on your director's report?
Actually, I've asked Clay Cole to provide a brief update on some UI items under the executive director's report.
Good afternoon, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Cerna. For the record, Clay Cole, unemployment insurance. A couple brief updates. First, relating to changes to the weekly unemployment insurance benefit amounts that affects claimants that file new initial claims on or after October 4th, 2020. This has no effect on existing claims, only new claims with initial claim date on or after October 4th. As you may recall, in accordance with statute, specifically House Bill 567, every year a calculation is done by the Labor Market Information Department to determine whether there will be any change to the unemployment insurance weekly minimum and maximum benefit amounts. This year, Labor Market Information has completed those calculations and determined that based on the increase in the annual average weekly wage from covered employment, which was last year $1,103, this year now $1,143, there will now be a resulting increase in the unemployment insurance weekly benefit amounts for claimants. The exact calculation is that the maximum weekly benefit amount is 47.6% of the average weekly wage, and the minimum is 7.6% of the average weekly wage. But with House Bill 2273, there's a tolerance set so that the maximum will not increase any more than $14, and the minimum won't increase any more than $1. So taking all this into account, basically our weekly maximum benefit amount currently at $521 will rise to $535 per week, and then the minimum will rise from $69 per week to $70. And again, this only affects existing, not existing claims, only those claims beginning October 4th and after. And finally, UI continues to track Hurricane Laura disaster impacted claims. As of today, TWC has processed 2,110 disaster impacted claims. However, the president has yet to issue a disaster declaration for individual assistance, which triggers the disaster unemployment assistance benefits. So right now we're just continuing to monitor that. So no changes there, but that gives you perspective of how many disaster impacted claims we have tracked through our systems to date, right at 2,110 claims. And this concludes my update, and I'll be happy to answer any questions.
Thank you.
Questions here, Chairman?
Nothing here, sir.
Thank you, Clay.
That's all I have, sir.
You're welcome.
All right, thank you. The time is now 2:57. The Texas Workforce Commission is now going into executive session to discuss pursuant to Texas Government Code Section 551.0711, pending or contemplated litigation in reference to pending bid protest to RFO number 3201900145, and to discuss the appointment, employment, evaluation, reassignment duties, discipline, or dismissal of the executive director, internal auditor, executive staff, or other personnel pursuant to Texas Government Code 551.074A1. Okay. The executive session is now concluded. The time is 4:11. Is there any other order of business come before the commission? None. Do we have a motion to adjourn?
Chairman, I move that we adjourn.
I second that motion.
Been moved and seconded that we adjourn, and we're adjourned. Thank you, everybody.
Thank you, guys.
Bye, everyone.